Again, I am Sid Mendelson. Immediately on my right is Stan Judd. Immediately on his right is Sid Simmet. And on his right, Larry Bardfeld.
I would like to continue to discuss the section that we were talking about at the end of the last segment, Section 3C3, which excludes from the definition of investment company, among other things, banks and bank common trust funds, both of which I believe we've said enough about. I'd just like to spend a moment talking about the third exclusion provided for in that section, which I think is of some importance, and that is the exclusion for insurance companies. Arguably, without the exclusion in Section 3C3, insurance companies might literally come within the definition of investment company, although I suppose you could get some argument on that, and as well you could get argument on the point whether or not banks would be investment companies but for the exclusion. But policyholders, of course, of insurance companies are not investors in every sense. They seek normally protection against loss and not merely gain. As noted in the discussion that we had earlier about Section 3A, a company issuing predominantly variable contracts is not entitled to the exclusion because they're not conventional insurance contracts, and so the insurer was held not to be an insurance company meant to be excluded by Section 3C3. Likewise, if the company is issuing in the main, I suppose, guaranteed investment contracts, which is a new kind of product that is cast as an annuity, and that product, by the way, was the subject of a recent release, which you might want to look at. Even though those contracts are funded from the company's general account rather than any segregated separate account, it's conceivable that if the company were predominantly engaged in issuing such contracts, that company might even not be entitled to rely upon the exclusion from the definition of investment company for insurance companies, although I think in most cases we've seen the insurance company exclusion obtains to the situations. If variable annuity contracts of a large insurance company run out of a separate account, that is, an account that consists only of a small part of an insurance company, as we discussed in the Prudential case, we saw that the separate account is a person and is separate from the insurance company, and the insurance company exclusion does not take that person out from under the Investment Company Act. I guess the moral of these various examples is that a fund, even though it has no separate existence, can be an issuer. Recall, too, the First National City Bank service, which was determined, in a sense, to have been an investment company, even though it was within a bank, and the bank has an exclusion.
I would like to say something on insurance companies and how we have viewed it and how the courts have viewed the insurance companies issuing insurance policies vis-a-vis investment contracts or securities. It appears that the courts, as well as the Commission, have underpinned their theory on who is bearing the investment risk. If the policyholder is bearing the investment risk, it's a security. If the insurance company is bearing the investment risk, it's an insurance policy. I'll give you an example. An annuity, a true annuity, sold to a person who is expecting to annuitize at age 59, and he's guaranteed in the tables that for all the money that he's guaranteed 3% a year accumulation on his payments. And at the time that he annuitizes, the table says you will annuitize at $6 a thousand of accumulated value in your account. There, the risk is totally on the insurance company. Likewise, if the insurance company says, if you will die, we'll pay the estate or your named beneficiary an amount stated. There is a contract which is guaranteed by the insurance company. It's insurance. On the other hand, a variable annuity is the payment on a variable annuity depends upon the investment experience of the account and that person's pro rata share of that investment account, in effect. So that if the investment account rises at 10% a year, his accumulation units will rise by 10%. Conversely, if the investment experience drops 5% in any particular year, the value of his accumulation units will drop by 5%. And so the risk of investment, the investment risk, is on him. So that at the time that the annuity is figured out, at the very beginning, it depends upon the total investment activity of the account while he was accumulating. And subsequently, after he gets what is known as annuity units, the amount that he will get from month to month varies with the record, the investment record of the account, and therefore he's always at risk. So he bears the risk. This is an essential ingredient of a security, as opposed to a contract of insurance. And this is, I would say, this is if I had to put my finger on one underpinning of the Commission's position and the Court's positions in determining whether we're dealing in insurance or whether we're dealing in investment contracts, it's who bears the risk. Now there are other measurements, but this is I would say the biggest, the most important measurement. Yes.
What is the position on a package that is put together that has a guaranteed minimum return as far as annuity, and if the experience is better, then the policyholder would benefit from this? Is this partial security or
no?
Security?
The question was, what is the effect if there is a stated minimum benefit which can go up with the experience of the investment experience of the account? I think this is a case which the United Benefit Insurance Company litigated to the Supreme Court, and there they held that amount of casting the burden of investment experience to the shareholder, to the policyholder, made the contract a security, and therefore they held that United Benefit had to register as an investment company, and its securities would have to be registered under the 33 Act. It's interesting in that particular case that the court found 9-0, that it was a security and an investment company, but that in the first case, the variable annuity case, that the court only found 4-5, and the person that wrote the dissent in the variable annuity case wrote the majority opinion in the United Benefit case. So in answer to your, I think I've answered your question.
I just want to clarify one thing I said before. I'm not sure everyone understood it, and it's not a settled matter. I suggested that if you found a company such as VALIC was doing with respect to variable annuities, issuing only guaranteed investment contracts, which are a new insurance product styled as an annuity, some of which may be securities. They're not necessarily securities, but if a company was issuing solely guaranteed interest or guaranteed investment contracts and doing no other business, and if the contracts that they issued were deemed to be securities, then I suppose conceivably that the company itself, the issuer, might not be entitled to rely on the exclusion in the Act for insurance companies. I don't think that's the case we've had so far. I want to now pass on to Section 3C11.
Can I just make a point? In these so-called GICs, Guaranteed Investment Contracts, I think this illustrates to a large extent how the Commission views various instruments that are said to be one thing, but are really something else. In GICs, in Guaranteed Investment Contracts, the insurance company, mainly through broker-dealers, were selling contracts in which they agreed to pay 7 or 9% for a period of guaranteed for 2 years. Thereafter, there was no guarantee, and in 4 years, for example, the contract expired, and the person would really either take his money out or take an annuity. And they would sell these things to anybody that wanted to buy them. A person 21 years old, for example, could buy a guaranteed investment contract and an annuitize at age 24. Well, you know that nobody is going to annuitize at age 24. It's economically it's not feasible. So that they by calling it an annuity, doesn't make it an annuity any more than if you call a horse a zebra, it makes it a zebra. And in this release that Sid Simmet mentioned, it goes into what really constitutes an annuity in the eyes of the Commission. And that which doesn't constitute an annuity must be a security. That's the inevitable conclusion that one must come to. But the point that I'm making, whether you're dealing with the 33 Act or you're dealing with the 40 Act in this Commission, you don't take it for what the issuer says it is necessarily. You look to see what it really is.
The second of the two exclusions from the definition of investment company that I want to talk about now and that I had mentioned when I began is found in Section 3C11. I'll paraphrase what 3C11 says. 3C11 essentially has 3 clauses. And the first clause says if you're a pension plan qualified under Section 401 of the Internal Revenue Code, you're not an investment company. It talks in terms of a trust qualified under Section 401. The second clause says if you're a fund consisting solely of the assets of such 401 trusts, and you're a bank collective trust, you're also not an investment company. And the third clause says if you're an insurance company and you have a separate account which relates to variable annuity contracts, and the only money allowed in that account is 401 pension money, then that account does not have to register as an investment company. Now, these obviously, if you think about it, are the exclusions for employee benefit plans or pension plans or retirement plans, call them what you will, And they exclude from the regulatory provisions of the Investment Company Act all individual, corporate, and KEO, that's H.R. 10. I hope you're familiar a bit with what that refers to. That refers to retirement plans for self-employed individuals who aren't covered by corporate plans. And it excludes them from the regulatory provisions of the Investment Company Act if the trusts meet the requirements for qualification under Section 401. That's Clause 1. It also excludes all corporate and H.R. 10 or KEO employee benefit plan trusts that are commingled in a collective trust fund consisting solely of such assets, that is, assets of such trusts, if the collective fund is maintained by a bank. We'll see in a minute what that's supposed to mean. And that's Clause 2. Now, the separate exclusion in Clause 2, you should realize, indicates that these commingled accounts, and they're all trust accounts that are being commingled, could not rely on the exclusion in Section 3C3 for bank common trust funds, even though this is a trust situation. And one has to assume that this kind of trust was not regarded as the kind which, if placed in a common trust fund described in Section 3C3, would be appropriate. And so a separate exclusion was provided. Now, you should also note that Section 3C3 says that it must consist exclusively of assets over which the bank is either trustee, administrator, executor, guardian. This, I believe, says the collective trust for pension monies must consist solely of pension monies. Now, if you have a collective fund for other kinds of retirement plan monies, then presumptively they are subject to registration under the Investment Company Act because there is no exclusion of them for them. For instance, if you had a collective fund consisting solely of what is called Section 408 IRA plan money, there would be no exclusion in our view under the 40 Act for those accounts, even if they were run by banks or insurance companies. Now, let me make this point, that the only collective funds for pension monies that are excluded are those that are run by banks or insurance companies. If they're run by someone else, then in all likelihood, in other words, even if you had a mutual fund, an ordinary investment company, and you restricted the holders of the shares to pension plans, that would not relieve you from the registration and regulatory obligations of the Investment Company Act. These exclusions, where there is a pool of pension money involved and it's only 401 pension money, just run to banks and insurance companies. That's the Clause 2, Clause 3 part of Section 3C11. Now, again, Clause 1 excludes the 401 trust of a single employer, and we have also said that this exclusion covers trusts which cover employees of majority or wholly owned subsidiaries of the employer, so-called related companies. If people ask us, by the way, to take no action under Section 3C11 Clause 1, frequently they ask when there doesn't seem to be any apparent reason for asking. We generally, nevertheless, condition our no-action response on their getting a favorable Internal Revenue Service ruling. Now, notice when you're talking about the 401 qualified pension trust of, let's assume, a single employer, there are no conditions in that Clause 1 exclusion. That is to say, anybody, even though the thing meaning the trust will tend to be bank trusteed, there's no requirement that the bank be the investment manager of the trust. you can hire anybody, T. Rowe Price, to tell the bank what to buy and sell. That's a so-called direction trust. On the other hand, well, let me, before I go on to Clause 2 and make the distinction, let me note that there's been a question raised as to whether Clause 1 covers trusts of employees of several companies where the trust is the result of labor management negotiations between one or more locals of the same union and various employers in the area or industry involved. And that question is before us now, and we said we would consider the Clause 1 availability to such situations on a case-by-case basis. Now, if you're not a Clause 1 trust, if you can't rely on Clause 1, then you presumably are a collective trust. But, as I pointed out, you're not excluded from the definition in Clause 2 at any rate, unless you're maintained by a bank. Now, we say maintained by a bank in this context means that the bank has to have and to exercise substantial investment responsibility. It can't be a mere custodian. We have said, however, that there was somebody running around the country, this is how I think it all started, saying, look, all you doctors, send your money to Bank X and have them pull it, all your KEO money, they all had these HR 10 plans, have the bank pull it, but don't let the bank manage it, because banks are notoriously poor investment managers, so this person said, who happened to be an investment advisor. Rather have the bank take its investment direction from us, insist upon that. And we said that wouldn't be a collective fund maintained by a bank. However, we did say that if the bank took full responsibility, in other words, it could receive suggestions as to what to buy and sell from a third party so long as the bank took responsibility for it. And if a bank was willing to do that, it would layer the costs involved. That might be sufficient to find that the collective trust was maintained by a bank. Now, the collective trust has to contain, again, only 401 money. And if you mix any other kind of money in there, such as 408 money, you probably lose your, not probably, but you do lose your exclusion. The third clause and the final clause of Section 3C11 has to do, as I mentioned before, with separate accounts of insurance companies. Again, they have to, in order to be excluded from the definition of investment company, since they're normally required to be registered as investment companies, the only situation in which they're excluded is where they contain only money from 401 qualified trusts. Now, frankly, Clause 2 and 3 put banks and insurance companies, pooled funding media for 401 plan and trust money on an equal footing. I think I'm going to stop at that point. If you have any questions, I'd be happy to entertain them.
Now, the point, I think, of Sid's very technical explanation is that exceptions and exemptions from any statute are construed narrowly and normally are construed against the person attempting to assert the exception or assert the exemption. And so that they are technical, and since they and we apply them, generally speaking, very strictly, and that is what necessitated this rather technical discussion of the various clauses that Sid went through.
The balance of the exclusions from the definition of investment company in Section 3C will be described to you by Larry Bardfeld.
Okay, because the questions more frequently arise under Sections 3C5 and 3C10, I'll discuss those first. Section 3C5 excludes companies primarily engaged in one or more of three businesses. The first two are particularly related to each other, and those are acquiring notes, accounts, receivables, or other obligations representing part or all of the sales price of merchandise, insurance, and services and the second is making loans to manufacturers, wholesalers, retailers, and prospective purchasers of specified merchandise. Now those two obviously are pretty broad, at least on their face, but the legislative history of the section makes clear that those aren't as broad as might appear, so that simply a company engaged in making loans to sellers or purchasers of merchandise would be excluded under those provisions. Rather, they were intended to provide exclusions for companies such as factors, which might purchase the accounts receivables of a company, for example, a company which sold automobiles and in exchange took back notes, installment notes, to finance those purchases, or companies which provided financing to manufacturers based on specific accounts receivable, which form the collateral for loans. The third type of company in Section 3C5 is a company which acquires mortgages and other liens on and interests in real estate. In addition to the more obvious real estate investment trusts, that exclusion would generally include investment company-like entities which closely resemble ordinary investment companies, except that they specialize in mortgages or other interests in real estate. Because of that resemblance and the fact that those companies attempted to capitalize on the popularity of mutual funds, Congress in 1970 amended Section 3C5 to exclude, and this applies not only to those businesses which are investing in real estate, but also the other two types of companies. But it excludes any such company, or prohibits the exclusion from being relied on by any company which issues redeemable securities. That's in addition to the limitation that had always been in the section prohibiting any issuance of face amount certificates or of the installment type or periodic payment plan certificates. Now, one variety of real estate venture which cannot rely on Section 3C5C, the exclusion applicable to real estate ventures otherwise, is a company which invests in limited partnership interests in other companies, such as an investment company relying on 3C5C. Although they cannot rely on that exclusion, it is possible, and the staff has said in a release, that they might be able nevertheless to be excluded from Section 3A1 because they're not really engaged primarily in investing securities, notwithstanding the fact that they're invested in other limited partnership interests. If, in fact, through, for example, their general partner over which they have control, they control the businesses of the underlying limited partnerships, so that those two-tiered investment companies might take themselves out of 3A1 depending on how they're operated. In addition, the staff said that we might be able to give no action comfort under Section 3A3 of the Investment Company Act, which would also present a problem for such companies if they, for one thing, were not within Section 3A1 and could rely on their opinion of their counsel that was in fact the case, and that if this is reasoning essentially analogously from the exclusion from the provision in 3A3 for majority interests in subsidiaries. If they owned more than 50% of the limited partnership interests in the companies in which they invested, then under those circumstances we might be willing to take no action. In addition, the staff has said that under 3B2, under some circumstances it might be appropriate to grant an order to the effect that the company was primarily engaged in a business other than investing in securities. And finally, depending on the circumstances, the company might be granted a 6C exemption. Section 6 will be discussed later by Stan. Section 3C10 deals with, it's a so-called charitable exemption. That is, it excludes from the definition of investment company any company organized and operated for charitable purposes, no part of the net earnings of which inures to the benefit of any private individual. Now, it's generally the same entities which would fall under that would also be tax exempt under Section 501c3 of the Internal Revenue Code. And in fact, Section 3C10 was derived from a predecessor of 501c3. Now, usually this provision does not present any difficulties when one is dealing with an individual charity. The problem more frequently arises when you have a number of charitable organizations which want to pool their funds for investment. Now, where you're dealing with related institutions, such as member churches of a particular religious order, and the fund is under the control, directly or indirectly, of those participants, then we've said that we've been willing to take no action positions under those circumstances. However, when you're dealing with a group of seemingly unrelated charities with really no nexus, no overall control of the fund, then we would most likely be unwilling to take a no action position. That is, merely because the participants in a fund are charities doesn't make that fund itself a charitable institution. But when there is a requisite nexus between all the participating charities and the fund itself, then it might be viewed as a fund which is a part of the overall charitable organization. The other context which is related to Section 3C10, and we received a number of no-action requests under with respect to this aspect of the provision, is it deals with pooled income fund trusts, which are under Section 642C5 of the Internal Revenue Code. That permits the pooling of funds contributed by donors to charitable organizations, in which the donor retains a life income in the property which is donated. However, there is a charitable deduction for the remainder interest, which is irrevocably donated at that time. Although we've been willing to take no action positions, we have been unwilling to say that our position is based on Section 3C10 expressly, but we've nevertheless given them comfort, providing they provide written disclosures that fully and fairly describe the operations of the fund, and we've reminded them at the same time that, in our view, the anti-fraud provisions of the federal securities laws would apply to the sales of these interests. And the second condition that we've imposed is that any solicitations on behalf of such funds be by either outright volunteers who receive no compensation whatsoever, or employees of the charity who do not receive any special compensation for their soliciting activities. Now, there are a few remaining exclusions under 3C, some of which are relatively obscure and
Larry, let me just interrupt you. I want to make it clear on the I think you did, but I want to say it again for the benefit of the audience, that I think with respect to pooled income fund trusts, where you give money to a college, for instance, and it's an irrevocable gift, but the college takes your money along with similar money and pools it and promises to give you whatever interest the pool earns, but will never give you back your principal. Then if you look at 3C10, it says no part of the net earnings of which inure to the benefit of any private person or party, whatever it says. Clearly, 3C10 would not be available as an exclusion from the definition of investment company to a 642C5 pooled income fund trust. Rather, we took a no-action position in reliance on several factors that Larry mentioned, and perhaps the principal factor is that people are making gifts. We assume they have a donative intent, and there are Treasury Department and IRS rules and regulations that govern how these pooled income fund trusts are to be run.
What about a charity that wants to have contributions made of some large principal, but it is concerned that the people who might be making the gifts might someday need to invade that principal. So what they do is they set up a revocable trust, or an arrangement in which they agree to pay the person who has put in the money. They agree to pay him 6% a year, let's say. Would you consider the payment of some interest rate of that type as causing the entity to lose any possibility of coming within Section 3C10?
Did you say revocable trust?
Yeah, it's a revocable trust.
Well, I would think that there, obviously interest comes from profits, and I would be inclined not to grant a no action.
You say,
well, the interest, the 6% or whatever you just mentioned.
Well, supposing a company went out, supposing a charitable organization went out and borrowed money. We wouldn't say that merely because it paid interest on the monies it borrowed that it no longer had a charitable exemption.
I think that that's different. I think that here where you're soliciting, if you in fact are soliciting people for revocable trusts, the theory is that you are and you're not doing it in the what I would call as a private placement. It would seem to me that you are making, one, you are making a public offering, and two, that you couldn't afford to pay 6% unless you were going to use the money for investment, and this would, in effect, be a share of the profits. I realize that in many instances we do not consider interest as being a share of the profits. But I think in the case that you just posed, I would not be inclined to give the no action letter. I think it's a borderline situation, but I would not be inclined to give it.
Wouldn't it seem if the interest rate is sufficiently below market rates that it might be argued that there's still a donative intent? And
I think all of those factors come into play, but assuming they're giving, assuming for a moment that they're giving either an excess interest or excess of the and they're giving the donor the opportunity of getting back his money. It seems to me that this operation is being run for something other than a charitable organization, and that is to benefit. But as I say, I think it's a close question. I would be inclined not to give a no action. I'm not so sure whether a company not having asked whether we would go enforcement, necessarily go the enforcement route. But I certainly would not would be very hesitant to give a no action.
Let me make just one point, though. Of course, we must recognize that the only time the exception becomes necessary is if the charity is an issuer, and an issuer of a security, and a security being something, if someone has given some money to them, for them to invest to make a return for the person on. So we start with the idea that that's possible. That the mere fact that a charity is offering a security, that doesn't mean that it's automatically not a charity anymore. Otherwise, there wouldn't be any purpose of having the exemption to begin with.
Well, as a practical matter, Stan, there are charities which issue securities which allow the donors to vote, but don't allow the donors to benefit in any profits that the charitable investments have made. And I think that the pure statute, I think the pure purpose of the statute was to make sure that where a person retained voting rights or something that seemed to be characteristic of a security, that the charity would not be penalized by being forced to register. I think that going back to Larry's talk with respect to factoring and things of that sort in 3C5, I think that one has to realize that technically every one of these companies that he mentioned was an investment company, but the Congress, in its wisdom, didn't want to get in, didn't want the 40 Act to apply, and by excluding those companies from the definition of investment companies, it took them outside of the Act. One item that he didn't mention, which is in fact a company making small loans. Did you mention that? Did somebody?
3C4.
Yes.
Yeah.
Well, obviously, a finance company, a little small loan company, people come in and borrow money and give their notes. This is the portfolio of this company. The Congress just didn't want to take that company into the orbit, if you will, of the 40 Act, because that wasn't what it really meant by an investment company, that people investing in a finance company would have the protections of the Investment Company Act. A finance company was just not one of the companies that the Congress wished to include in that orbit. Yes, sir.
Yes, sir. It seems to me that you run into a problem sometimes when you try to distinguish a finance company from an investment company. Because I know in some situations I've run across companies termed finance companies, in which what they do is make loans and equity investments in other types of companies to the tune of $400 million or more. I have problems at that point seeing the size of the total assets of this company, calling them a finance company as opposed to an investment company when their portfolio is so large in terms of total assets, and the companies that they are investing in total 60, 70 companies.
Well, now obviously a small loan, a company under 3C4, a person that is primarily engaged in the business of making small loans or industrial banking, it was never contemplated, I don't think, that a small loan would consist of $5 million of financing or something of that sort. So I don't think it comes within, the exemption comes within 3C4. I think it may well come within 3C5, and there, if you'll notice that the amount of money, there is no connotation that the loans would be small. I think you just have to take to look at it this way, that the Congress felt that it was not appropriate for these companies, factoring companies, companies that were lending on the specific purchases of merchandise, were the type of companies that the Investment Company Act was contemplated in getting. In other words, I think that the legislative history, even though there is some information to the contrary, we're talking in terms of fungible securities and tradable securities. And the further away you get from tradable securities, the less apt the Congress was to include it. And the type of notes that you were talking about are usually kept by the company that lent the money. They are not traded in the marketplace as a normal operation. I think this was one of the, while not the only indicator, one of the indicators. Secondly, I don't think you should ignore the fact that this statute was subject to a lot of pressure groups. For example, the real estate investment trusts obviously weren't in existence, but there was a great many people lending money on mortgage companies that wanted to make damn sure that they were not brought under the Act. And so they lobbied for this, and they were successful. And I think all the other companies, a good number of the other exemptions here, were the result of pressure lobbying, convincing the Congress that they should be excluded. And I don't think one can always apply logic to why one company is out and another company is in. This Act is most subject to pressure groups that wanted to make sure that their point of view or that they was taken, or that they were excluded. And in many instances they were successful. The banks had their pressure groups. Insurance company had and still have their pressure, which they apply with a strong hand every time legislation comes up, including 1970 when this Act was amended. So that I don't think I can answer you with logic.
Just to mention quickly the remaining exclusions in Section 3C. Section 3C2 excludes underwriters, brokers, and dealers who, obviously because of their activities, might otherwise come within the Act, but there was no intention of regulating them as investment companies. Sid just mentioned Section 3C4, a person substantially all of whose business is confined to making small, that is, consumer loans and industrial banking or similar businesses. Section 3C6 excludes companies primarily engaged in combination of businesses described in Sections 3C3, 3C4, and 3C5, and also excludes them if 1/4 of their gross income is from those businesses. They may also engage in other businesses other than investing in securities, that is, other than being an investment company. Section 3C7 previously excluded any company subject to ICC regulation or controlled by such a company. That was amended in 1976 after the Penn Central collapse. Penn Central Transportation Company falling within that exclusion, and Congress being generally outraged by the fact that the Investment Company Act's protections were not applicable in that situation. So that at present the only entities that are excluded are motor carriers, and even those can be brought within the Act if the Commission declares them to be an investment company. Section 3C8 excludes companies which are subject to regulation under the Public Utility Holding Company Act, presumably the theory being that they're subject to pervasive regulation, although, as has been the case with several other regulatory statutes, we've often considered them to be directed at different purposes and not supportable as substitutes for the Investment Company Act. But again, it probably reflects another congressional compromise. Section 3C9 excludes persons substantially all of whose business consists of owning or holding oil, gas, or other mineral royalties or leases or interests in them. The Commission for some time has urged Congress to adopt limitations similar to those in Section 3C5, that is, that these companies be prohibited from issuing redeemable securities, however, or face amount certificates of periodic payment plan certificates, but it hasn't been so amended. The one thing to note in the language of Section 3C9, because it is broader than 3C5 and includes investment contracts with respect to those interests, there's no problem similar to that in 3C5C with the two-tiered real estate companies. That is, under 3C9, a company investing in a limited partnership which was engaged in investing or owning oil royalties, for example, would be similarly excluded. Section 3C12 excludes voting trusts whose assets consist exclusively of securities of a single issuer, which is not an investment company. And finally, Section 3C13 excludes securities holders' protective committees. And that's all of Section 3C.
I think that one thing that I think is happening is that the nature of the kinds of things that the ordinary, let's say, investor might be investing in is changing. That if you look at the Act, I ask myself the question is, are those entities which the Act regulates, does the Act regulate them because it wants to protect the people who are investing in such entities, or does the Act regulate them when those entities themselves are engaged in the securities industry because of the general public interest in the securities industry? And we've been saying here this morning and afternoon sort of is that except insofar as face amount certificate companies are concerned, that's basically the case, but in face amount certificate companies, because of the nature of the instrument that's being sold, that is a fixed obligation to pay you a certain amount of money, which is purchased with a series of installment payments, the fact that unsophisticated people buy it, that there was a protection of them. But when you see what's happening today with people setting up funds that are investing in diamonds, investing in gold, investing in antiques, investing in paintings, and people buying shares in those companies, and you would think that those people probably need as much protection as the people who invest in investment companies. Nevertheless, it's quite clear that there is no regulation over those companies under the Investment Company Act, that there is regulation under the 33 Act, 34 Act, and so on, but not under the Investment Company Act. Now we're beginning to move into areas that are not quite clear, with people who are now setting up funds to invest in commodities and commodity futures, and we're beginning to move into funds that are investing in commodities futures, which consist of futures on Ginnie Maes and futures on T-bills, and there's going to be a large question as to whether that kind of a company comes within the Investment Company Act or whether we've been excluded from jurisdiction by the Commodity Futures Trading Act. So those are some of the leading cutting edges now of what's happening in this area of investment company and exempted from investment company.
Well, in answer to you, Stan, I think my experience has pretty much indicated that those situations will not come under regulation until there are large amounts of fraud or overreaching, which brought out the Investment Company Act. People today, in this mode that we're in now, are not going to increase regulation unless there is, if I can use the expression, blood on the floor. That the facts will have to point to the absolute need for regulation, and it only can be done after the fact, after investors have lost a considerable amount of money from overreaching of some sort, which will bring into play an act not dissimilar to the Investment Company Act.
So far we've been talking about exceptions from the definition of an investment company. And now I'd like to turn to another section, Section 6 of the Act, which creates exemptions for investment companies from the provisions of the Act. In other words, We're not talking now about exceptions from the definition of an investment company. We're talking about exempting an entity which would be an investment company from the provisions of the Act. There are several exemptions. The first of which, Section 6A, creates an exemption basically for a company which is operated in a possession of the United States and which sells its securities only to the people resident in that possession, such as a Puerto Rican company, a company in Guam, or something of that type. There are a series of very limited exemption, limited applicability. Basically, they applied to certain companies that existed at the time that the Act went forward. Companies in bankruptcy before the effective date of the Act, certain reorganized companies, certain companies exempted by the Federal Savings and Loan Insurance Corporation, and companies which before March 15, 1940, was and still is a subsidiary of a face amount certificate company and is an insurance company. Those exemptions are, as I said, very limited, and I don't think you're going to come across any of them. In addition, there is an exemption under 6B for an employee's security company. That is upon any order granted by the Commission upon application by such a company, which is basically a company whose investors are employees, or families of employees, or the companies themselves. In addition to which, the most important exemption under Section 6 is the exception presented by Section 6C, which gives the Commission the authority to exempt any issuer from any and all provisions of the Act if it finds that the exemption is necessary and appropriate in the public interest and consistent with the protection of investors as indicated by the policy and provisions of the Act. Now, in that connection, it's very important on an application under 6C that from exemption from a particular provision of the Act, one looks to 1B of the Act, which Sidney mentioned earlier today, to determine what the interests of investors are that the Act was intended to protect. And we will continue with our program later on this afternoon.